Hello there.
Hi.
Hi. Thanks to everyone for joining us today. This is our Fathers and Divorce webinar. I am joined by our Dallas-based partners, Ryan Segall and Andrew Speer. One is a dad, one is a dad-to-be. One of the hosts wanted me to make sure I address the fact that one is not an actual dad, but will be fairly soon. Andrew, do you have any dad advice for Ryan that you've been giving him?
Get as much sleep as you can now. That's it.
Okay.
Yeah.
Well,
I'm already stressed out about my hair is falling out.
and a disclaimer to all of our guests, there will be a few dad jokes trickled in. I've already gotten a warning. I can't help it. Hey, I can't stop them. My name is Katie Justice. I'm the sales and marketing director at the firm. If you've called the firm before, you've most likely spoken to me or someone from my team. We handle the intake and kind of the client onboarding, and we kind of help with all of the people that are calling the firm and questions and want to set up a consultation. We help with that. So we got lots of questions submitted from people that have registered for the webinar, so we'll start with those. I'll be alternating between Ryan and Andrew. If you have any other questions or a follow-up question, or you forgot to submit a question when you registered, you're welcome to submit a question in the Q&A, and we'll get to them as time allows. As we get towards the end, I will put our email and phone number within the chat so that you can follow up there if you want to set up a consultation or speak with one of us directly on your situation. I'll make sure you have our information to do so. If you have to jump off the webinar, we will have this recorded on our website by the end of the week. So without further ado, I wanted to start with a couple questions that we get all of the time from people calling the firm looking to hire a family law attorney. So I kind of wanted to start with some of those. I even got two today, and then that will kind of help kick things off, a warm up, so to speak, if that's okay. So Ryan, I was going to start with you just because you've done these webinars before. So what are the chances of a father getting 50-50 custody in Texas?
Sure. Well, first of all, thanks for having me, Katie. Just glad to be here.
Oh, sorry. Was I just rambling and not letting you guys speak? I'm so sorry.
No, it's okay. I'm just happy to be on here with you and Andrew. Just our firm showing some real commodity here. So 50-50. Good question. Question we get all the time. I really think a lot depends on knowing your judge and knowing what your judge is apt to do, because some judges out there are just not 50-50 judges. And so you need to go into these mediations, court settings, knowing what your judge is likely to do, what he or she is unlikely to do. Sometimes the strategy is asking for primary instead of a 50-50, because if a judge isn't going to give you 50-50 and you're not asking for more than 50-50, judge may very well say, well, the other side, we're just going to give the other side primary. So I think that is something to consider. The other thing I always tell clients is a 50-50, I mean, it may sound good in concept, but you always want to consider what the actual breakdown in percentages is. Andrew, I know I hear different numbers all the time on this. I think it ends up being a standard possession in Texas, probably about a 53-47. Sound right? Maybe?
Sometimes people throw around 48.
Right. Right. And so, when you're talking about a 50-50, you're maybe talking about a few days here and there. And so you can negotiate with the other side and say, okay, fine, I won't take a 50-50, but maybe I'll take what we call an expanded plus, which is maybe a couple of extra days every other week or so.
Throwing
And that'll
off
get you.
Thursdays, right?
What's that?
Throwing some off Thursdays or Wednesdays or something like that.
Right, exactly. So maybe you get 2 days on the off weeks that you don't have the weekends, and that way you can get towards pretty, pretty damn close to the 50-50 without actually having the 50-50. I think a lot of times people think in their minds, I'm dead set on this 50-50 when, when you're a couple days short of it, it's not really going to make that big of a difference. So that's kind of my thoughts on it.
You might also want to bring up that a 50-50 doesn't mean no child support.
Yeah, and you'll hear that a lot when it comes to, why is someone asking for a 50-50? Because right or wrong, sometimes judges will think they're only asking for a 50-50 for no child support. And to Andrew's point, what courts will often do in a 50-50 is kind of net out the two child support amounts. And so there's a lot that goes into the 50-50. I tell clients, make sure you know what you actually want as far as the 50-50 goes. You may be able to vary from it a little bit because at the end of the day, it's really about kind of what works best for you and your child. So,
All right, Andrew, I'll ask you the next one. And this is, again, a question that we just get all of the time. Do fathers have the same rights as mothers? I think I get potential new clients calling all the time, wanting someone that specializes in fathers' rights or someone that's really kind of focused on that. So tell us a little bit about fathers' rights.
Statutorily, they do. Okay. So based on statute, you can't discriminate based on gender. In the courtroom, generally, I mean, I've had a great success getting dad to be the primary decision maker on quite a few things. It really depends on the parties and their past actions, right? So who's normally doing everything? Also, who acted first? Who moved out? Like, where did the parties live? Like, who's actually dealing with the schools, the teachers, and things like that? And then also your jurisdiction. Some jurisdictions are always going to give the party, well, not always, let's say, they start out by default giving the party with the right to determine the primary residence the exclusive right to invasive surgical decisions, psychiatric decisions, and educational decisions. They just bundle them together. So if you're in one of those jurisdictions, you're going to have a litigation focus on untangling them, right? You want to undo the combo. If you're in a different jurisdiction, they may all just be independent. Generally, the default is going to be independent rights to everyone as a joint managing conservator. I actually, I'll be like, I've had dads get primary and the exclusive, they call it head, med, and ed, right? Rights. More and more these days. I wouldn't say, I think they've got the same rights. I think it's more of a situational thing these days. Sometimes you may have to approach case differently if you're dad than if you're a mom. And you may have to, if you want those rights, I mean, you just display them differently, your evidence and things like that. But generally, they have the same rights.
yeah. And I guess, Andrew, I know you and I have talked about, sometimes you're in a court and you're like, maybe the deck may be stacked against you if you're representing a dad.
Yes. Well, you have to
So
attack differently then, right? You have to do a
right,
different approach if you're in one of those courts.
right, and of course you always have the option of a jury trial if you do want to, have a full on custody battle. If you're in one of those courts, I like having the jury because you and I have had good success in the past, or great success rather, in the past of with jurors, because I think juries do like to see a dad who's ready to step up, and I think that is always an alternative if you do land in one of those courts. So
Yeah. And they tend, at least in my experience, I mean, we've done a bunch of jury trials together. I feel like they tend to see through the BS a little better.
I agree.
So that is one way to do it. Now, the jury can only do certain things, right? But it will bust through some of those hindrances that may exist.
Right. So I'm going to get started on the questions that we got submitted. So the first one, Ryan, how can I obtain 50-50 possession? My ex is not willing to negotiate, and we have our second mediation coming soon.
Well, I think we kind of addressed that in the first question.
Right.
So, I mean, if I can expand on that if you want.
Well, there's the mediation component.
Right. I mean, I think it goes to what we were saying before as far as, when you're negotiating this 50-50, just getting close to it, sometimes it's not worth fighting over a few extra days. You push and say, look, I know my bare minimum in court is, if it's a standard possession schedule, like Andrew and I were talking about, it's, maybe a 53-47, 52-48 split. So you say, okay, they're not willing to give me a 50-50, but you know what? I know my bare minimum is 48% of the time. So maybe I'll just split the difference in, 49%. I tell clients again, not to get hung up on the numbers and the percentages. It's really about the schedule and what the schedule looks like as far as how it's going to go. So, I mean, at the end of the day, you're not going to get it unless you both agree, you're not going to get a deal done. But that being said, you should be able to push because you know that your bare minimum is going to be a certain amount of days. And going in there and say, okay, I'm not coming off X number of days. I think that that's an important stance to take because at the end of the day, you can sit on that stance and say, look, I'll just roll the dice in court because that is where kind of the leverage and negotiation comes in because you want to be able to go into court and the other side has to have some sort of a risk. If they don't have any risk, they're not going to have any exposure and they'll say, fine, we'll go to court. But that's where I think, maybe even asking for primary in your pleadings and saying, you know what, if we can't agree, I'm asking for primary. We'll see what the judge does. So, I mean, Andrew, thoughts?
Well, it's because it's in mediation, it's throwing me off. If I was going into court, my ideal fact set would be parents who live a few blocks away within the school zone, same school zone, right? And both parents are always going to doctor's appointments and PTA meeting or parent teacher conferences, not really PTA meeting. That's what I would want because the closer the parents live to one another, the higher the likelihood of a 50-50 being just workable, right?
Yeah.
They live 50 miles apart. That's a lot of car time for a kid.
Sure.
But I mean, if you're in mediation, that's what you're going to wheel and deal, right?
Yeah. Yeah. And that's a good point is you can always, when you're talking about mediation, you can put things out there that the court would never do. I mean, you could argue, if it's a divorce, you maybe give them a little bit more on the property side, and then you'll get in exchange for some extra time. I mean, it's things that you can always use to negotiate because money talks, and sometimes that's the way that you can get certain things that you may want on the child side of things. So, I know some people don't like to hear that, but it's the truth.
Okay, next question, Andrew. What is a realistic expectation for a possession schedule for a dad who works full-time and a mother who has been the primary caregiver during a marriage?
Okay, so if the mother has been the primary caregiver, then I'm going to assume that the judge is going to award her the exclusive right to designate the primary residence. And generally, there's a presumption in the family code of a standard possession order, which is now automatically expanded. And that's what would, let's assume if we had like AI robots doing everything, right? And they were the judges now, that would just be the auto that's what everyone's getting. That's where you'd start. Now you can tweak things. It depends on the court. But if she has been the primary caregiver and we have no reason or bad acts by her to change that and stop the status quo, at least at temporary orders, you're probably getting an expanded standard possession order, which is going to be, every other weekend, but you're also going to get the Thursday to Friday during the school term, and it'll end on Monday instead of Sunday. And then in the summer, it'll just be the every other weekend, Friday to Sunday. Then you'll get a big chunk of time, around a month in the middle of it, and alternating holidays. So, and that's roughly this 48, 47, 52, 53 split we've been talking about. That is what will likely happen. It doesn't matter that dad, the full-time working, this could be if both parents were working full-time, the judge is going to determine who's the primary caregiver, if we want to use that word. And that person's going to get the 53% part of it, and the other one's going to get the 47%, most likely, unless you've got other evidence and reasons why it should change. Okay. If we're both starting at neutral, like there's equal parenting, it's a different scenario. But if one parent, I'm gonna be honest, I don't care that it's the mother, because I've gone in and shown that when it's the father, they get the primary, right? It's going to be an expanded standard possession just by default, okay? Assuming they live close enough. No one's over 100 miles away, something like that. I don't know. That's my answer. Ryan, you got anything on that?
Good transition. No, I mean, I think you nailed it. I mean, I think here's what I tell clients is, unless there's some sort of wild, circumstance or something like that, you're going to walk into court, you're going to get a standard possession schedule. I mean, that's pretty much what's going to happen, because these, a lot of judges will just say, standard possession, rubber stamp, call it a day. It's just easier. It's the presumed best interest of the child. And that's what courts are going to do. And obviously, as we talked about before, you can negotiate that and everything and argue it. But typically, I think that's what's going to happen if, one parent's out there and the other parent's the primary.
Sometimes the judge will give you like a test period,
Sure.
If they're not sure what's going on, they'll make you jump through. They're normally not very major hoops. They'll put a feue hoops out there, see who screws up, and go from there too. I've seen that more and more. They give a parent the opportunity to disqualify themselves.
Yeah.
Yeah. So it's wild out there.
We have a couple questions that people submitted that I think we probably need a little bit more context on the situation, but I guess we'll do the best we can. So Ryan, this one is for you. I've been denied all visitation since 2013, and my ex lies to my son that I don't pay child support. What advice would you give?
Well, if you've been denied the visitation since 2013, I mean, obviously a very extended period of time, you got to go into court and you got to ask for some sort of orders, some sort of relief. And what that may look like, it may be an enforcement if there's already an existing order. If there's not an existing order, then you got to ask for orders. It's been so long in this scenario. It's been so long that the court's going to put stair steps in place. It may be supervised visits at first. It may be a reunification counselor. It may be a combination of all that. But that's what is going to happen, especially if there's some sort of alienation going on between the mother and the child against dad. Then obviously dad's going to need to unbundle that and make sure that the child is prepared to have the visits, and that's going to be the important thing. Andrew, you and I have both worked with reunification therapists in the past. I mean, it's an unfortunate scenario that they're brought into things, but typically, if the child is accepting of the process and dad's willing to jump through the hoops like you talked about, I mean, they'll get their visitation, and if mom's not doing it, then you file an enforcement on the issue. That's basically your relief. So,
I also think it matters how old the child is.
well,
So,
sure,
so let's say 2013, let's say they are 11, right?
at the least, yeah.
Yeah. If they're 11, you've still got some time here to fix this with reunification therapy, right? I've had one where now the kid's 17, right? And so we were then getting visits going, having like family members, like one of the siblings who wasn't alienated, also go to all the visits and try to work things through. But it gets more difficult the older the child is, because eventually the court just loses jurisdiction, right? And the judge isn't going to order reunification therapy for 3 months, right?
Right. And unfortunately, there's sometimes, depending on the age, like you're saying, I mean, if the child's 17 or, about to be 18, I just tell clients it may not be worth it to go through the litigation process. And maybe you just end up, once the kid is 18, reaching out. And I mean, they're going to be able to make the decisions, and they can kind of see, once they get older, they can see what's going on. There's it's just an unfortunate situation. It just depends on how old the child is at that point and what can and can't be done by the courts. Because, like you said, the second the kid turns 18, the court doesn't have any jurisdiction for the access and possession part. So,
All right, Andrew, this is the question we got. Why is my wife automatically designated primary caregiver?
Well, it probably wasn't automatic.
Yeah, right.
So most of the time, the judge has to make a decision on who's going to be primary caregiver, right? Normally, people aren't living right next door to each other to make a 50-50 workable. And someone has to have the right to determine the primary residence. I guess you could put it within geographic restriction, but that's not common. Judges start with presumptions and then work away from it. You've got to rebut the presumptions essentially, and everyone's going to be a joint managing conservator. There's a presumption of that, but who's it going to be who designates the primary residence? That's what I'm considering primary caregiver in that sentence to me. And I mean, it's going to be based on what was like, who was going to whatever appointments, right? That's what it's going to be. Who was taking care of the kid more of the time.
taking to
Also,
school, things like that.
the school.
I said taking the
Yeah,
kid to
taking them to
school.
school, doctor's appointments, whatever, and the age of the child. Um, Generally, I'd say so. A standard possession order starts as a presumption at 3. So if they're under the age of 3, it's going to be something working its way to it, but they're more likely, I guess, to keep a newborn with the mother as the primary caregiver, but not for all of the time. I'll be honest, I've seen like a lot of mothers try to use breastfeeding as an excuse as to why dad can't have possession until they turn 3, and that just doesn't work. Judge will say, bottle it up or give them formula. I don't care. Go buy, right? And so that's not going to really change, but it's a common argument that comes up. I don't think it's automatic. There's some other factors going on. It may have felt automatic, but there's facts behind it.
Yeah, I mean, I will say this, in that I have both moms and dads who will come to me and say, "Why is it in this court that the other side is automatically gets XYZ. So everyone thinks the court is stacked against them. So, and 99% of the time it's not. There's the 1%.
Yeah, I mean, it's gonna be, we like to say who's holding the ball, right? If you're playing football, who's holding the ball is gonna be able to score a touchdown easier, right? And so if mom has been with the kid more, probably going to be appointed the primary caregiver, if we're going to use that term here, more often.
Good sports analogy, Andrew. I'm proud of you.
My sports analogy, thank you.
Yeah, that's nice. That was good.
Big sports guy.
Okay, next one, Ryan. What are my rights if I want to move to another state and the mother and I currently have joint custody?
All right, so we're gonna have to take this. There's gonna be two different ways here. So let's assume scenario one. Let's assume that this webinar question asker. That's what I was going for. Let's assume that person is primary. If they're primary, there's typically going to be some sort of geographic restriction that says you cannot move from a certain area. That area may be a school district, it could be a county, it could be one county and what's called contiguous, which is touching counties. So as long as one side is in that area, the other side, whoever's primary, usually has to stay. So you need to look at your orders to see what that geographic restriction is. I mean, it is something that the courts are going to put in place close to 100% of the time if the parties are living together. I've had many clients who have asked, what we can do about that geographic restriction. Honestly, if both parties are participating in this child's life, it is virtually impossible to get that geographic restriction lifted. Now, that is if you are the primary and the other side's living close to you. Now, let's go to scenario two, which is the other flip side of that. Let's say the other side is primary and they are subject to a geographic restriction. You can move wherever you want. You can, Maine is beautiful this time of year. Why not? So, you can move anywhere. Either parent can really move anywhere. The court has no jurisdiction to stop either parent from moving anywhere. The court has jurisdiction to stop the child from moving anywhere. So it's a de facto, whoever's primary can't really move unless the other side moves away. But you can always move. The issue, of course, will be looking at your order and seeing what the possession schedule looks like. So, if you have an expanded standard possession schedule, which is, basically first, third, and fifth weekends, let's call it just Friday after school through Monday morning, plus some Thursdays during the school year, that's going to change once you move out of state somewhere. Your possession schedule, Texas has what's called an over 100 possession schedule, which basically gives more chunks of time. So you get more days in the summer, you'll get every spring break, things like that. So you can move. You just need to make sure what, depending on if you're primary or not, what that possession schedule is going to look like. And it happens all the time. And that's why that over 100-mile possession is in there, so that if somebody moves away, they're still going to have their time with their kid. So.
Well, and if you move, then they can move sometimes.
Right.
Most of the time, the parent without the right to determine the primary residence, once they're out of the geographic restriction, most orders will lift the restriction on the other parent. So you move to Maine, I mean, other parent's going to go to Hawaii and have fun making that flight, right?
Well, and what's also the kicker on that is you have to be very careful because, DFW, I know you live kind of on the border on one of the counties, and if your geo restriction is, let's say, Dallas County, and you move across the street to Collin County, that geographic restriction lifts. That person can move wherever they want. And so you have to be very careful about that.
And then there's also, which zip code is it? 75287, which is Dallas, Collin, Denton County, right?
I have no idea. Yeah,
There's
that's
one,
north. That's out of my jurisdiction up
yeah,
there.
there's one area that is all three counties within Dallas City somehow. And people screw that up all the time, filing the wrong court, things like that.
Yeah.
And so if you move literally across the street to like a different house or a different apartment complex, whatever, you have now left a geographic restriction in some cases.
Yeah, and I mean, I know that we had a case way back when, and somebody moved, not very far, and the other side just took up and moved to California. Nothing the other side could do about it.
Yeah.
And it's you got to read those decrees carefully. Very, very important.
All right, Andrew, next question. What are signs to look for if I'm worried I'm being alienated from my kids as the divorce process begins?
Okay, so if they start using real weird language that sounds like it could be used in a case, you'll get this a lot. They start using essentially if well, I guess if the other parent starts saying best interest of the children a lot, then it's a big clue, but that's not the question. But the kid will start saying weird things, like they'll use the word possession more or something like that. They start using terms out of the family code. If they suddenly are like hesitant to be around you, and you're like sitting there going like, what the heck has changed here? A lot of times I've seen that when one parent is alienating the other one, the kid just randomly becomes scared, and the other parent's like, what, wait, what the heck just changed? And it's normally if the other parent is just feeding fear and stuff into them while they're in their possession. So if they suddenly become hesitant, if they start using litigation words, that could also mean they got a hang of the decree, by the way. A lot of older kids, sometimes they start Googling and get a hold of parts of the family code. And that's kind of weird because of course, they get it wrong. But it's a plot twist you don't see coming. What other signs? Hold on. If signs look for if I am worried, I am being alienated. Okay, if the other parent is constantly contacting the child during possession, to where it's distracting, right? If, let's just say, parent two is just texting nonstop, parent one, normally not a good sign. Proving alienation is a lot of legwork, okay? And it's going normally you've got to get counselors and experts and things like that to actually prove it. Everyone seems to have found the words gaslighting, narcissist, and alienation in Google or Chat GPT, whatever they're using. So those come up a lot. And also, if you're going to look for an alienation expert, you have to let your attorney do it because a lot of these people online don't meet the qualifications for what you want as someone to testify in Texas regarding these issues. I've seen a lot of these random online alienation experts, and they like won't even tell you what school they went to and things like that. It's real weird. Don't trust them. You need to have someone who like can actually testify appropriately. What else? Yeah, that's it. That's weird language, weird hesitations, constant contact, things like those are just they don't always mean it, right? But if I'm gonna say like these are the red flags, that's what I would think of.
Yeah, I mean, I'd throw in there, constant asking of, well, the child said this or the child said that over when, it's, but yeah, to your point, I mean, you should, if you do think it's happening, talk with your attorney, talk with an expert, again, recommended by an attorney, because
There's a lot of fake ones out there now.
yeah, sure, why not?
Right.
Yeah, Google University.
Ryan, and this is a question we get a
Yes, Katie.
lot. I think I talked to this gentleman a few days ago, but can I modify our custody agreement if the mother is in a new relationship and I have concerns with him being around my kids?
Yes and no. I mean, on its face, yeah, you can certainly make the argument, but you have to have a good reason. I have seen multiple cases in which one side files a modification just because they don't like the third party. They don't like the new boyfriend. They don't like the new girlfriend. And so you have to be very careful about why you're actually filing. If you look, there's going to be a stepfather, there's going to be a stepmother, that person's going to be involved, and there's not a whole lot you can do about that. Now, that being said, if there's actual concerns, if this person has history of drug abuse, if this person has an extensive criminal history, things like that, and you can prove, hey, this guy is a bad guy, or this woman is a bad influence, and here's all the supporting documents of that. Yeah, you can certainly ask the court for injunctions. You can ask the court for modification of possession. Um, and typically, what the court will do is they'll make specific injunctions against. You can't make injunctions against the third party, but you can enjoin the other parent from doing certain things, such as, not allowing that new boyfriend to be around the children unsupervised, something like that. So that's where your modifications will usually tie to. Obviously, if it's something extreme, abuse, things like that, then yeah, the court may very well remove the child and flip primary. So there's different levels. Obviously, you want to talk with your attorney, figure out, hey, here's what's going on over there, here's what I think's going on, here's the proof that I have, go from there. And then your attorney can figure out, hey, is this a case worth pursuing? Because I've had clients come to me and tell me, hey, dad gave my kid a haircut and I didn't like the other, or sorry, stepdad gave the kid a haircut or something. Like, don't file something for that. But there's if obviously if it's an intense thing or an extreme situation, then yeah, you go ahead and file and put it to the court. You just want to make sure that you have the documentation and the evidence that backs up why you're asking for what you're asking for.
Generally, you're going to want a third party expert, you're going to want a kid's counselor or something too.
Yep.
I did something similar to this recently. I don't want to go too deep into it, but we had a third party, right, expert, and our goal we weren't at the stage. It's kind of sad to say that you don't want to have to wait until a kid is abused before you act, right? But if a kid is abused, you must act. But we weren't there, right? There was no abuse going on. And so you just try to modify it to minimize exposure at that point. But you need to have, you have to have a harm to the child. And it might be emotional or developmental. And you need a third party to say, if it's just mom is filing because there's a new stepmom or something, or she doesn't like her, it's not going to work. There needs to be more than that. You're right about that. But no, we've had shifted time, right, to minimize exposure.
Right. Yeah, I mean, and it can be anything. I mean, I've had cases where I've defended it too, and it's just a jealous ex who doesn't like that their former spouse has now moved on. And sometimes it's just ridiculous. Someone goes to a bar or something like that. I heard about this one story where a neutron walked into a bar. Bartender said, "For you, no charge."
There it is. Shocking.
How many more?
You see how I worked that in there? You see
how many more do we have of that?
Oh, don't worry. There's a couple more, but I'll figure out how to get the pirate ones in. Yeah, we'll figure out how to get those in. But that's how I worked that one in.
All right. Okay.
Next question. What do we got?
Just breaking it up a little bit here is getting, I want our audience to stay on their toes. So,
Good. Andrew, we mentioned that I think you talked a little bit about this, but one of the questions, the next question was, how will schools be determined in a divorce? My ex and I will be living in different school districts. She'll be staying in the same school district our child has always attended, but the one I just moved into is a higher ranking school.
I would say my first question would be how much higher ranked and where are we starting from, right? If we're starting from, bottom 100 school, I know I'm just making up numbers here, right? And moving into a top 5, maybe I've got something to work there, but going from 15 to 10 or something like that, that's not going to move a needle. And also, to be honest, the judge during the case probably going to want consistency for the kid, probably going to keep the kid in the same school. A school district alone generally is not going to be what makes a judge decide primary. It's a secondary factor, if anything. Now, once again, if we're talking, I don't want to get into specific school districts, but bottom 100, if there's a massive gap, like massive, and they're in a very bad school district right now, maybe you got something there. Also, those rankings are all over the place. So I don't know.
I mean, I think a lot of it though is really determinant on who's primary. I mean, I think
I'm
that's the
starting with no
biggest.
primary, right? That's how I'm doing it.
Yeah, but and I kind of agree with you. I think it's more of a secondary thing. I think that the judge, whoever's going to end up being primary, whether it's temporary, like I said, I agree with you that on temporary orders, the judge is going to kind of keep consistency and want the kid to stay in the same school.
Yeah.
But I think at the end of the day, whoever's primary is probably going to be the one to make that education decision. You can negotiate it in mediation otherwise, but typically, like you said earlier, with the primary comes the bedhead and ed decisions, and education is one of them. And the typically whoever's primary is going to get that one. So.
Well, yeah, and then the school will typically be determined based on their residents anyways.
Right,
It's not
exactly.
an educational decision. But once again, like it's got to be a real bad school, like really, really bad. That's a secondary factor at best, I think.
Yeah.
All right. Ryan, what can I do if my ex is not using child support payments for the child's needs?
You remember the case we had with the stacks of money on the grill?
Yeah, actually, I was talking about that case recently.
Oh, okay.
Katie, just a quick side note here.
Please.
We had a case in which the other side. This was a wild case, but the other side had claimed that he was indigent and had no money. But we had photos from the social media where he was literally at a like a grill, like a grill you cook food on, and he had stacks of cash that he was on his I don't know if Instagram was really around at that time, but
No,
he was flipping stacks of cash on his grill, and so the judge later found he was not indigent. So good times. Good times.
But let's say he paid that money.
Oh yeah. So back to your question, Katie. Sorry, I digress. So if it doesn't, honestly, here's the thing.
She starts using it on the grill. Okay.
You know what? She takes your child support. She puts it on the grill. Guess what? It's not going to matter. The court's not going to care. I hear this argument time and time again from people who come in and say she's got all this money. She's not using it for the kid. She's buying Louis Vuitton. Blah 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 blah. Unfortunately, in Texas, it doesn't matter. It is you're ordered to pay your child support. What the other side does, you can't really control it. You can now if you're having trouble with expenses such as extracurriculars or something like that, and it's obvious that the money is completely being wasted, you can try to ask the court to start apportioning extracurriculars or something like that. But in a basic child support of one party paying guideline support, which is typically 20% of their net resources, they're not going, the court's not going to order that they have to be going to certain things. I mean, I mean, I'm sure you've had it too, Andrew, just countless cases where the other side, the one, whoever's paying the child
Want to put it
support
in a
will
trust?
say, yeah, they want to put it in the trust. They want to pay it directly to the schools, to the daycares, whatever it is. The court's not going to order it. The court's going to order one side to pay the other side and how they use it. Because here's the other thing about it is it may not look like the other side's using it, but when you think about it, the money is just being paid into a pot, right?
An
And
offset.
that pot
Right.
goes to, right, it'll go to rent, it'll go to food. So it may not look like they're spending the money on the child specifically, but they may indirectly be. And that's kind of where the courts are usually coming from on this is this person's going to have rent, they're going to a mortgage, they're going to have food, they're going to have health expenses, and those have to get paid from somewhere. You just can't not pay those. So, unfortunately, there's not a whole lot you can do about that. Like I said, extracurriculars. Andrew, I don't know if you know of anything else off the top of my head, I can't think of anything of ways that you could, other expenses that the court may apportion out. Maybe college at times, or not college, I'm sorry, tuition for like private school or
Tuition.
something like that. Yeah,
Um,
that may
if
be
they
one.
if they're already in it too, like they're
Yeah,
not. I think once I got private school, that's going above. That's different. Sorry.
yeah.
Um, yeah, and also, I mean, there are just some hard costs associated with the kid, right? There's gonna be like the cost of food and things like that. And so let's say you see her wasting it on something else, doesn't mean she didn't pay it. Uh, but the judges just don't care. They're not gonna go.
No,
Now, if
that's
there's over guideline, what if it's over guideline, right? Somehow we've got an over guideline situation, and now we've got mom in Vegas, with the giant drink at a casino at a craps table, right? Maybe then we've got
now we're talking my game. Yeah.
yeah.
Okay.
Um, then you
Like a
could
yardstick? Are we talking a
we're talking
yardstick?
yardstick, yeah,
Okay.
the whole thing,
Okay.
no friends, just herself, craps table, and a
No
yardstick,
friends. This
ready to
is now
go.
turned
Yeah.
depressing, but okay, we'll go from there.
Um, that because you're already above guideline, maybe then you got it, but beyond that,
Yeah, that's true. Yeah, I think that you can use the expenses. Heck, you could use them on toiletries, paper towel rolls, things like that. This pirate walked into a bar. He had a paper towel roll on
Ryan.
his head. He had a paper towel roll on his head. Bartender goes, "What's the deal?" He goes, "It is a bounty on me head."
yeah.
Did you look up dad jokes before this?
No, these are all up here, baby.
Those are
Okay, we have one last question, Andrew, to wrap us up. How can I increase my chances of getting more visitation time?
you have to be involved. So once again, you're going to start. It's gonna how much visitation time do you already have, right? That and how do you use the visitation time you have, and how much more do you want? Let's assume we're in a situation where someone's trying to get essentially the expanded standard plus, right? You want to throw in a bonus midweek or something like that. That is tougher. Let's say if you always do an activity or something or some sport with the kid and is very important to your child, that might be a way to add that on. Sometimes it might just take it away from somewhere else. So If you're trying to flip it, that's very difficult. So more visitation, your starting point is going to matter. Let's say you have an old order with just a standard possession order that isn't automatically expanded, and you want to expand it. You could, that is easier to do than to go beyond that. Let's see. Increase my chances of getting more visitation. You're just gonna be involved in everything. It's just all gonna be about involvement. And it's not gonna be I hang out with the kids. Like you gotta you gotta thread the needle carefully here. You don't want to just be super dad all the time, right? You have to have some quality time, not at whatever practice or whatever tutor. But if you have a fun activity that both of you do a certain day of the week or something like that, or every summer, or there's like a family trip to Maine that you've done the last 10 years, right? And it's always on this weekend, you can ask the judge to get you that, always have that carved out. And I've seen them do that most of the time. If there's like a tradition, they will allow it to continue. But other than that, you have to be involved. That's it.
Yeah, I mean, take the, showing up to doctor's appointments, showing up to school things, initiating things. Yeah, I mean, just I agree with you.
Doctor's
I mean,
appointment
it's.
is not that like intimidating, by the way. You just like
I mean, I go to
ask
doctor's appointments all
questions.
the time right now. I go to one like once a week nowadays.
Well,
We're on a first name basis over there. I hold my wife's water bottle. I look at the little monitor. They show my child
water boy.
rotating around. Oh yeah, I'm the water boy. I haven't dropped it yet.
Do you do these dad jokes during those appointments?
Yes, I made a. I'm not going to say the joke that I made here, but I definitely make the dad jokes in the appointments, and often a similar reaction that you two give me, which is kind of stonewall.
Yeah,
Like,
I
okay.
never had much luck with them during. I always got very bad reactions.
May
No.
I recommend not bringing those jokes when it's baby time?
I mean, I'm happy to. I mean, here's the thing, Katie, you can't stop it. You can only hope to contain it. And that's, I get it. Honestly, I've seen these videos. I'll probably not, I'm probably going to get out of the room because, or Eileen will toss me out of the room, one of those two. So
That's a goal is, don't get kicked out of the room. That was what I told my husband. I'm sure, don't do the thing that's going to get you kicked out.
I don't know that I mean, if my wife kicks me out though, I don't know that that's really
By your
my
wife.
fault.
Yes, specifically by your wife.
Yeah. So
Okay.
we're going to a CPR class tonight. So
Good for
I'm gonna
you.
learn to.
Hey, that's a good thing you could do as a parent, though, right? If you have a young child, right, and you want to have more time with them, taking a parenting class, or like a child safety class, they offer them at hospitals is a good thing you could do to get yourself more visitation.
Sure.
And
Or,
show that
or you could tell dad jokes. I mean, another one I've heard is
Don't do
no,
it.
I'll finish up with this one. No, I gotta finish up with this
Okay.
one.
All
This is
right.
my
One more.
go-to.
That's it.
Katie, what is a pirate's favorite letter?
R.
No, you'd think R, but it's really the high C's that he loves.
Okay. Well, I think you can go to a parenting class that sometimes helps you with the judge. Okay. So I think we got a useful kernel from the dad jokes. I've seen that help, and I've gone into court saying my client's taken whatever CPR class, and that a judge positively looks on that as an affirmative step to get you more visitation with your kid. So,
All right.
and particularly when they're under 3.
Well, Ryan, Andrew, thank you for joining today. This was great.
Thanks for having us, Katie. We really appreciate it. It was great.
I put our firm's phone number in the chat. You'll also get an email afterwards to kind of follow up if we can help with anything else. We'll be here for you. So thank you and happy early Father's Day.
Thank you.
Happy early Father's Day, everybody.
Early to Ryan. but early to Andrew.
Right. Yeah, it gets us like a year early for me, but that's okay. I appreciate it.
All right, thanks again.